So now we come to the topic ethics and law. This is one of the important topics in ethics course, which you'll realize by going through past year papers. Some of the questions I have put down here for your ready reference. So let's see the UPSC questions. 2015 question number 1B, differentiate between law and ethics. 2015 question number 3A, a mere compliance with law is not enough. The public servant also has to have a well developed sensibility to ethical issues for effective discharge of duties. Do you agree? Explain with the help of two examples where number 1, an act is ethically right but not legally. Number 2, an act is legally right but not ethically. And question number 2016, question number 5, law and ethics are considered to be the two tools for controlling human conduct so as to make it conducive to civilized social existence. Discuss how they achieve this objective. Giving examples show how the two differ in their approaches. Right? So you can see in these questions and many other questions which you will be going through in the past year papers. One of them will be doing at the end of this slide and this presentation. Law and ethics is one of the favorite topics of UPSC. So first of all, we come to law. What do you mean by law? Law is nothing but it is these are the norms of a society, norms of a legal system, right? It could be norms of a religion which are codified as in laid down, right? Codification as in they are clearly laid down that you have to do this thing or you don't have to do this thing, right? Aquinas says that law is an ordinance of reason for the common good which is promulgated by those who care for community. And law gives the direction to people to act in one way and avoid acting in another way. It should conform to human nature and it should be just and for the common good, right? So law, all in all, is a clearly laid down direction to tell you that you have to do this thing and avoid this kind of action, right? But eventually we'll see, when we'll come to the difference between law and ethics, we'll see that law in a sense is made for few general cases. In some particular specific situation, how do you need to act? Law cannot specify every other situation, right? In another sense, law is a bit static. Even though amendments is going on even in the constitution, and law changes according to the demand, but changing law takes a bit of time. So action taken by a public servant in case of a situation which he comes across, which is not clearly laid down in the law, in which he faces the dilemma, he has to be driven by other principles which will come to later, right? So law typologies of law are of largely four types: natural law, law of nature, divine law, and civil law. What is natural law? Natural law is nothing but something which is in accordance with our nature, which goes with our human spirit. Natural law, just to make you understand, as soon as you are born as a human, you have certain kind of laws you are given as a human. Like for example, right to life, right? That is a natural law. You have a human dignity associated with you. That is a kind of natural law, right? Human dignity means what? We'll come to the topic of humanism and existentialism. Probably I'm planning to do that separately. I'll also be dealing with topics like democracy and things like that, which will help you not only in ethics but essay and other GS papers as well. When you'll see what does actually humanism means, what does democracy means. Democracy is not just of the people, for the people, by the people. It's largely, it has a philosophical and humanistic concept. We'll deal it in detail. So, coming back to the natural law is about humanism. You are human, you are acting in accordance with nature, you have that human dignity. So any kind of right, these any kind of right, be it universal declaration of human rights or be it fundamental rights given in our constitution, or the rights in the US constitution or UK constitution, any kind of full-fledged democracy, the rights and laws are made in accordance with these natural law. If it is violating the natural law, supposedly any law is made which is violating the right to life, do you think it would sustain? It will not, right? So natural law is the primary law. You are human, एंड इसका मतलब अगर हिंदी में ही आप समझो तो प्रकृति के अनुसार, जो प्रकृति के अगेंस्ट ना हो, राइट? सो प्रकृति के अगेंस्ट कब नहीं होगा? जब when it implies to your human nature, right? So these are natural law. They are basically, if you talk about human nature, there are two, largely broadly two views of human nature. There are one kind of theorists like Aristotle who say that humans are benign, they are very generous, they are very good at heart, right? And the other view of human nature is human beings are selfish, they are brutal, they just think about themselves, and they, for their own interest, they like to kill someone else. So those kind of view is taken by Thomas Hobbes, and other philosophers like Rosio, and else. So they are the contractarians. We'll come to those thinkers as well separately. So human nature is largely divided into these two categories, these two thinking categories. But the natural law principle says that any kind of law, um, any kind of law which is in accordance with the nature, the human nature, right? Which fulfills the human dignity, right? So and the principle of humanism, we will come to about human, we'll talk about human dignity and humanism in detail separately. Second is law of nature. Natural law and law of nature are bit different, because law of nature is prakriti ke niyam, like sun rises in the east, like change of seasons. These are law of nature, right? Which is very not very pertinent to our discussion in ethics. Similarly, divine law is made by God, Old Testament, New Testament, those kinds of things are divine law, right? And civil law or positive law are one and the same thing, in which the law is made by the state, the state or representatives of state. Those could be constitution, those could be any kind of delegated legislation, right? Rules, regulations, those are civil law, right? So mainly in ethics we'll talk about natural law first, and fourth is civil law and natural law. So when we see the difference between law and ethics, we'll be discussing natural law and civil law. So, what is natural law? As I told you, natural law is based on human nature, and human reason can discover it, right? So, as the reason evolves, right? Human reason evolves over a period of time. So, the natural law evolves as well. Many things, there could be many things which were not natural laws 500 years earlier, but over the period of time, as the human civilization grows and people think and they know that yes, these kind of principles should conform to human nature, so those are adopted in natural law. Examples are right to life, right of freedom. uh, Being human, we need this law as our rights and dignity of human beings. As I told you, uh, it's based on humanism. Humanistic law and natural law are one and the same thing. It develops over time because, as see, there's a concept called tabula rasa. Tabula rasa is nothing but empty slate. Some rationalists, some people say, a class of thinkers, they say that knowledge is gained through reason. Mind, when a person is born, mind is an empty slate, and as and when he makes experiences, he gets the knowledge of it, right? He reasons out things, so it is developed over time according to the reasoning. So natural law is evolves, and as the natural law evolves, so does the principles are included in it. And maybe when we come to the difference between civil and natural law, then maybe certain things which are not known today maybe may can be known later, right? Like for example, this homophobic thing going on, as in homosexuality. It was used to be thought as bad some 100 years earlier, right? But over the period of time, we see that homosexuality is not wrong, right? Humanistic principles prevails, human dignity prevails, right? So it comes under natural law, right? That's why so many protests. That's why the civil law, that section 377 is people are trying to annul that, right? So there are two characteristic of natural law: universality and immutability. Universality means these kind of laws, they are universal for all human beings, whether that person is in India or US or Japan or anywhere else on the planet. These natural laws are universally applicable to all, right? And they are immutable as well. Immutable as in they cannot be revoked, right? These natural laws are given. It tells you, natural law tells you how you are morally obligated to do certain act, right? And the natural laws do not manifest in same form, right? As I told you, that as and when reason evolves. So supposedly there are three kinds of people. There is an insane person. There is a child, child or maybe teenager who has developed a certain kind of reasoning, and a mature person. So all these three people, they have different kind of reasoning status. For them, natural laws are different, right? So for an insane person just saving, maybe right to life, he knows somewhere that right to life is there, right? He'll try and save life. But for a teenager, there could be things like lying or cheating is bad, right? And for a mature person, he can lie to save someone else's life, right? So the level of reasoning in all the three people are different. So the natural law develops in humans, manifests in humans in three stages: primary, secondary, and tertiary. Primary, for example, primary stages, lying and cheating is bad, right? Secondary stage could be that helping others, right? These could be secondary stage, to prevail the good of all, helping others. And the tertiary principle could be ki even lying is can be justified to save lives, right? Next comes civil law. Civil law is nothing but the laws enacted by state. This could be constitutional laws, laws which are under delegated legislation. Delegated legislation is nothing but when bureaucrats are making laws, right? And rules and regulations. We'll come to the difference between rules and regulations in a separate topic, in which we'll see laws, rules, and regulations, and conscience as source of ethical guidance. Now, civil law may vary between India can make some certain other laws. US could make certain other laws for their people, but natural law is common to all. Most of the civil laws, they try, all these states, they try that laws are made in accordance with the natural law, because until and unless these laws are not made in accordance with natural law, people will not follow it, right? So most of the time, in almost invariably all cases, like right to life, right to freedom of religion, right to equality, what are all these things? These are civil laws, but people do it because they are in accordance with natural law, right? Whenever there is a conflict between civil law and natural law, people are not obligated to follow the civil law. That's why the concept of civil disobedience movement. Gandhi used to do civil disobedience movement and he was praised. Why? Because that time civil law was not in accordance with natural law. However, Arvind Kejriwal in doing a civil disobedience is not allowed. Because why? Because he is going against an authority who is mandated by the 130 crores people of this country, right? Democratically elected government के against आप जा रहे हो. So this particular civil disobedience is illegal and immoral as well, right? But in that particular case, in times of Gandhi, that was illegal but not unethical, right? Because it was in accordance with the natural law. If civil law is in conflict with natural law, people are not duty bound to follow it. But if at any point of time you are violating the civil law, you should have that fortitude. Fortitude, we'll talk a lot about fortitude in fundamental value of civil services. Fortitude is nothing but courage to take action, right? Conviction, right? For fortitude, you should have that fortitude to accept punishment while violating the civil law, right? So now today I have given a question, that particular case study in your telegram group and other places, in which CM asks, in case of national calamity, he asks the two DMs to various DMs to come to the meeting, and in the way of the meeting, the two DMs who cross through a road, they see a couple met with the accident. One of the DM carries on to the meeting, and another DM takes the couple along with him to the hospital and could not attend the meeting. So what should us chief minister do in this case? So after getting through this civil law, natural law, ethics, I guess you will be able to handle that particular question. Just to hint you a bit, that CM, although those two DMs, both of them, none of them is wrong. Both are doing their duty. One of them is uh, being driven by the objective responsibility, that DM who goes to the meeting, he is obligated by the law, rules, regulations. He is obeying his superior, he is obeying constitution, because nation, district needs him, right? So he is also right. But then the other person, he is going by the subjective responsibility. He is looking after saving life. He is going by his own conscience of saving life of the person met with the accident, right? So both of them are right at their places. But what will a CM do? CM has no other option than to punish that particular fellow, because again it has been written that it has led to disastrous consequences in the district because of the pandemic growing. So he will punish that fellow who could not attend the meeting, because see, and that punishment, that particular DM, he will have to accept it. Why? Because he knows that he is violating the civil law. But then he has to have that fortitude, that courage to accept that, because anyway he is doing a duty towards his conscience. He is getting fruit. He is getting, although the CM may may reward the person who has attended the meeting and may punish the person who has not, yet that person who has not attended the meeting, he is taking fruit. He is feeling good by obeying to his own conscience, right? So he has chosen to go by his subjective responsibility. So in that particular case, he will, with all his heart and all his courage and fortitude, he will accept that punishment, right? So on these lines you can elaborate. You can also bring in teleology there, you can bring in deontology. So next we come with to conflict between law and ethics. So in most of the time, laws and ethics are compatible. As I told you, laws are made, civil laws are made in compatibility to natural laws. But ethics is more related to the natural law. Ethics, here when they are asking you law and ethics, they mean civil law, obviously, right? Law means law made by the state. So law and ethics, in most of the time, they are compatible, because civil law is in compatibility with natural law. But at times the civil law does not foresee all the situations, the specific situations, like this particular case of accident, right? So what should a person do is not clearly laid down anywhere, right? So there could be a conflict, right? Similarly, you can take the example of cyber crimes, right? 100 years earlier, there was no cyber crime, there was no internet, there were no things like that, so no law was there. Nowadays there is all the law about cyber crime and things like that, but earlier there was not. So with the growing technology, with the times changing, right, with the dynamic society, emerging issues, right, uh, the law changes, but still there is a static nature in these civil laws. So whenever there is a conflict between law and ethics, a person, a civil servant, needs to be guided by ethical principles, right? He should, what is to be done, he should see the object of the action, circumstances of the action, and purpose of action, which is dealt in a separate slide earlier when I told you the judging these three principles of morality: object of the action, circumstances of action, and purpose of action, to decide whether he should resort to what kind of cases. See, 99.99% of the time a civil servant goes by law, right? Because until and unless he goes by law, his action would be subjective, his action could not be predicted. But ethics is about predictability, right? He could behave in an inconsistent way, right? So in most of the situation he will go by law, but in this 1% or 0.1% of the cases he may need to act in discretion. That's why even in civil services conduct rule, in case of conflict of law and ethics, he has given this power, civil servant has been given this power to act in discretion, right? He has to see that what is the most bona fide decision, right? That's why he is there, right? Otherwise a machine could have been there, if only is to law is to be guiding principle, right? So a human is there, and human with so much of education, so much of ethical sensibility, so much of compassion, he needs to work in the interest of larger marginalized section of society. So keeping all these things in mind, he cannot be just complacent and say that okay, I'll save my life, I'll save my job, and I'll just go by the law. He is expected to be acting innovatively, acting in common good, and upholding the natural law, right? So whenever there's a conflict, largely whenever there is a conflict between law and ethics, he will be going according to the ethical principles, right? Another few of the other things we'll be studying later in the course, like how conscience plays an important part. Conscience is nothing but voice of conscience. It is something which is very subjective, your own internal intuition, what your own internal thing is telling you, right? uh, Conscience has multiple interpretations, psychologically, philosophically, right? So we'll come to the conscience and other things, other theories like virtue ethics and deontology, teleology, justice, how they guide when these two conflict occurs between law and ethics. But largely this is the case whenever there is a conflict between law and ethics. So next assignment is question number 2018 4A. UPSC has asked, in doing a thing, everything is permitted which is not prohibited expressly or by clear implication. Examine the statement with suitable examples in the context of a public servant discharging his or her duties. Right. So, see, this is one of the questions in which you could see that earlier questions in 2014-15 they used to explicitly ask the difference between law and ethics and things like that. But over the years, UPSC has evolved its question pattern as well. You need to identify from which topic they are asking. Like for example, in the earlier justice question, I told you they had asked this difference between law, Rawls and Sane concept. But then what justice question I gave you, there was no Rawls and Sane, but the answer more or less was similar of both the question. So over the times, topic is not changing, but their way of questioning would enhance, and you'll have to, until and unless you master the material in the course, you'll not be able to apply it tactfully in your examination. So just keep it in mind, and think, and keep studying. Let me know in comments in case of any doubt or questions. Thank you.